Hello to everyone who's just joining now. We're just going to wait for another minute to allow some other people to join, and then we're going to get going at that point. So welcome and bear with us for another minute or so. Great. We still have people coming in, which is always lovely to see, but we're going to get going. So hello, everyone. Good morning, good afternoon, good evening, wherever you are in the world. And welcome to today's webinar run by Gold Standard. This webinar is part of a series that Gold Standard has been running this year, looking at different topics that are important for the implementation of Article 6 of the Paris Agreement. My name's Hugh Salway, and I'm going to be moderating the webinar today. This series has been supported by funding from BMW UK, which is the German Ministry for the Economy and Climate Action, and we're very grateful to them for their support. And in this series so far, over this year, we've looked at some of the key parts of the Article 6 decisions, which have been agreed by negotiators last November. We've looked at how Article 6 is being implemented on the ground across the world. And we've looked at the potential for partnership between public actors and the private sector to make the most of Article 6 and to realise ambitious investment into climate action. And in today's webinar, we're going to be looking at something a little bit different. We're going to be looking at the value of credits generated under Article 6 of the Paris Agreement, how these credits or mitigation outcomes might be priced, how this might evolve in the future, and what the main drivers for this might be. And just to start off, we got a long way into the last webinar that we held before we received a very valid question through the chat function, which was simply, what is Article 6? And so we're conscious that there may be some of you out there who are less familiar with what we're going to be talking about in this webinar and with Article 6 itself. So just to start off with some of the basics, Article 6 is the part of the Paris Agreement that deals with international cooperation, typically market-based cooperation between countries, as well as with non-state actors. And essentially the idea behind Article 6 is that emission reductions or removals which are achieved in one jurisdiction, in one country, can be used by another country towards their NDC, or indeed by an airline or a non-state actor towards other targets which they may have. And at the heart of Article 6 are two terms that you're likely to hear quite a bit of today. So the first of those is corresponding adjustment or adjustment. And this basically refers to an accounting device, a kind of carbon accounting step, which a government takes in order to make sure that an emission reduction, which is achieved within its own jurisdiction, with its own borders, isn't counted towards that country's NDC, its nationally determined contribution under the Paris Agreement, but it can instead be used by another government or by a private actor with a unique claim to it. And the second term, which we may hear a bit of today, is authorization. And this is essentially the government which is hosting a project committing to apply a corresponding adjustment. So recognizing credits, mitigation outcomes, whatever you want to call it, as running under Article 6 and agreeing that it will adjust for them and allow another entity to take claim to them. And the question that we're really focused on today is, how will buyers, whether they are governments or private actors, value these emission reductions that are correspondingly adjusted under Article 6? And how might the value of adjusted credits, adjusted mitigation outcomes, diverge from credits that are not adjusted in the future? And just to set everyone's expectations at the right level, as far as I'm aware, we do not yet have a credit or a mitigation outcome that has been authorized for use under Article 6 of the Paris Agreement, and that exists in a registry somewhere. So when we're presenting you today and when we're going to hear from our panelists, there isn't a very strong data set with which we have to work. So please give some patience to our panel members, as you won't come out of this with very kind of clear answers on exactly what Article 6 pricing will look like in the future. But what we do hope is that we'll be able to provide some insights on this topic from early experience that we've had so far and from some different perspectives. So we have a really great set of perspectives on the panel today. And I'm just going to start now by introducing our panelists. So we're very honoured to have today with us Mischa Classen, who is Director of Carbon Procurement at the KliK Foundation, based in Switzerland. Ritah Rukundo, who is Technical Advisor on the Global Carbon Market Project at GIZ. Josh Brown, Business Development Manager at TASC. Russell Karras, who is Head of Carbon Market Development at CBL, the exchange. And then Malwina Burzec, who is an associate at the Centre for Climate Policy at EY Law. And across the panel, we have a really great set of perspectives. And what we're planning to do today is to spend about 40 minutes hearing from our panel, so one by one, and then having a little bit of discussion amongst the panel about the issues under discussion today. And then after that, we're going to come to your questions. So as we go through this webinar, please feel free to ask questions through the chat function, and we're going to answer as many of them as we can, and go through them kind of one by one as they come through. And I think that's it in terms of housekeeping. So I'm going to turn now to my first question, which, Mischa, is to you. It'd be great if you could start us off here. So, Mischa, the KliK Foundation has been involved in Article 6 preparations from well before the decision at COP26 last year. And you probably in the KliK Foundation have more experience than pretty much anyone else across the world in the implementation of Article 6 and in thinking about the procurement of mitigation outcomes. It'd be great if you could share a little bit more about the KliK Foundation's work, and then also just share a little bit more about what you're seeing from projects in terms of pricing. What are the trends that you may be seeing as far as you're able to share? And how is the KliK Foundation thinking about pricing for the future as well?
Thank you for that question. As you may be aware, the KliK Foundation is basically a private organization that is tasked through a quite complicated set of law, Swiss law, to procure the mitigation outcomes that Switzerland, as a party to the UNFCCC, has pledged to bring about through international ambition. So we are a compliance buyer and a private organization. And yes, indeed, this peculiar setup brought us to the forefront of being active and really developing and buying ITMO grade projects. Now, our experience, I have to admit, is the experience of an early player, and we do have experience. And of course, I'm not going to talk about prices now, and I'm also not going to talk about macroeconomic MAC curves, because they don't serve any purpose in that respect. But what I can clearly see is how we operate and how we see the market fundamentals to evolve, or that a possible trajectory. So first and foremost, we are looking at the generation cost. As I said, we are typically in primary transactions with project developers in very specific setups to generate activities that will become authorized in a near future. So this also implies that there is government institutions that are able to authorize. So for Switzerland is the only one. Peru and Ghana will follow probably next, and maybe Thailand. So there are a couple of countries that can produce this kind. Now, as I said, we look at primarily at the generation prices. Then a next level, which will be important, that's the question about the levies. We know now from the emerging national frameworks that there will be levies, there will be kind of deductions depending on the country, so that will play most probably also a role in pricing. Now, going forward, I think one of the more important price determinants is the question is an Article 6-ish activity. So we do not, at least that's the general understanding as well, we do not go in Article 6 into activities that kind of compete with the cheap options a country has under its NDC, because this would ultimately lead to not to an authorization, so we won't get anything out of it. So this Article 6 niche will be very important. And here I believe there will be a standardization, to come back to your question, like that some activities may be early on considered suited for Article 6 and replicated in different geographies. And then, of course, the top will be what's the willingness to pay. And here I can say we are far away from that point, but still, like in this gradient, of course, we may at some point reach that level because we are now very much in a buyer market, and I would expect to have a transition towards the seller market, and there, of course, the price signal would somehow refer to this willingness to pay. And here it becomes quite interesting because there will be different player. South Korea may have a fungibility with its ETS with ITMOs, so there will be a price signal. We will have very ambitious, large, also voluntary player that consider what would be their options to go ahead, do it themselves or buying it with adjustments. And so these will ultimately, like the marginal buyer will then set the price. So we are like evolving from this level triggered by primary transactions towards a higher level, most probably in the future, while voluntary and compliance markers as well, they will get closer and converge to some extent. That's my understanding of what's happening right now, but we are very early. Thank you.
Great, thanks for that. I mean, and there's some really interesting points there that hopefully the others will pick up on further down in the panel as well. So 3 other things which I picked up on there was the potential for levies first as part of the kind of the process and the steps which a government puts in place, a host government. Secondly, this idea of projects under Article 6 being different in nature to some which may generate cheaper carbon credits as well. And that's something which would be good to talk about a little bit through the session. And then thirdly, this point about the convergence of the compliance and the voluntary market, and the fact that you may have governmental buyers alongside corporate buyers looking for kind of similar mitigation outcomes. And all of these are things which would be interesting to explore a little bit. Ritah, we're going to come to you next, and some of these may feature in what you're going to say. So GIZ is working closely with both governments and with the private sector in East Africa and across the world to build capacity for the implementation of Article 6. And it'd be great to have a little bit more insight on how you see governments considering the value of mitigation outcomes that are generated within their country. And in particular on this question about, well, 2 questions. So firstly, how they're seeing kind of different hanging fruit, I guess you could say. So the lower hanging fruit, which they may want to keep for their NDC, and higher hanging fruit, which may be more for Article 6, whether you're seeing that coming through a bit in government thinking. And then also the question of whether they may want to retain some value in some way from credits that they authorize for use elsewhere. Over to you.
Great. Thanks to you. I hope you can hear me well. I'd got us. Yeah, good, great. Thanks to you, and thanks to the Gold Standard for inviting me to be part of this webinar. Like you mentioned, it's a very interesting topic and still going on quite a bit in the region. So just a bit of background, as I've been introduced, I work with the GIZ, Global Carbon Markets Program, based in Uganda, but we support countries in Eastern Africa as well, 7 countries in total. And this is with the support from the German Federal Ministry for Economic Affairs and Climate Action. And the support that we sort of offer is mainly around readiness for participation in markets, also seeing the transition from the CDM. And it's really a wide range of support. So mainly technical support, advisory, but also support with procedural aspects. So this we do particularly through a regional alliance called the Eastern Africa Alliance on Carbon Markets and Climate Finance, and this we are doing jointly with the support of the UNFCCC regional center based here in Kampala. So this is really support to both the public and private sector negotiators to have a stronger position towards the COP, particularly on Article 6 matters, markets generally, and yeah, overall also engaging the youth and civil society on still same aspects, climate finance and carbon markets. So mainly just to quickly go to the point that we're discussing, and of course also building on how important the partnerships have been over time, also through this discussion that we're having on authorization. I'm also really glad that we're working closely with the gold standard and with you and the team to develop a sort of step-by-step guide, or what we're calling a blueprint for implementation of the Article 6 rulebook. Uganda being one of the pilot countries, but we look to also undertake this in the other countries. So really in terms of authorization of Article 6 and the value that governments are looking into, how governments are looking into the value of the mitigation outcomes, I think one key point we're seeing is that while a lot of the discussions are still, like Mischa said, are still really at the nascent stage, there's still a lot to be done. The general outlook from the region is the importance to ensure, firstly, sustainable development co-benefits. At least this is now the view that we are seeing a lot in the Eastern region and a bit of the Southern African region, as a potential add-on, or as a very important add-on to mitigation outcomes. So this is also learning from the gaps and all the experiences from the CDM through this process of assessing the sustainable development benefits. So building on this, we see a lot of discussions, not just on the technical front, but also going into legal aspects and principles of environment and social integrity, and also linking this to national climate change policies that the different countries are developing. So I think in that view, sustainable development is important to sort of add that value to the credits, but also importantly is this relation, or the importance that each of these countries, both the host government and the buyer countries, are putting on the ITMOs that would then be transferred at some point, developed in one country, sold to another, and how these have a relation directly to the key NDC sectors for each of these countries. So of course, speaking to the NDCs, we also look as far as methodologies that are being applied, key sectors that are being involved. Primarily for the region is really energy, afolu, agriculture, a bit of industry, and understanding that countries in the region have expressed their intention to use markets, a lot of them within their NDCs. This is a very important factor for them, and we think will come out clearly as they sort of put together their regulations for authorization in terms of the weight of the mitigation outcomes from the projects. And then just to touch a bit also on the question, Hugh, that you asked around how Article 6 activities then could be considered as higher hanging fruit. Yeah, I think the hope is that Article 6 can support decarbonization of the hard to abate sectors, which have not been commonly, coming out very primarily through a lot of the country activities. However, this will require a lot of support and momentum from the different stakeholders. So likely a lot of the guidelines for authorization for Article 6 will build on previous experience or previous requirements that these governments put under the CDM, that this saw approval of certain technologies. I'll give example of renewable energy efficiency. So of course, these already are what I would call proof of concept, is what I think they've seen they work, they actually have an impact in the region. So likely they will look at some of these projects, but important for now, Article 6 and moving forward is the key aspect of innovation. So coming up with innovative technologies that look to higher betterment, high ambition. So a lot of these discussions really are looking at sectors outside the usual, outside the the ones that have been commonly done. And for this, we're also conducting through the Alliance, conducting a study on best available technologies in the region. So we hope that this study will sort of shed a light on some of the technologies that might be best suited for the region, and also which countries could look into those that they had really not necessarily probably thought about as key sectors. And then lastly, sorry, Hugh, sorry for taking a bit of time, but lastly, on the question you raised about taxation and the value, and likely if there will be additional charges maybe to project developers through the process. Yeah, this is a bit difficult to tell at the moment, but I think noting that there's additional expectations from the governments in terms of regulatory responsibility, in terms of the authorization process, which might not be one entity, it might be more than one ministry or one department. There might be a need to have this additional levy for especially administrative costs, authorization accounting, but still, this is something I know that is still under debate by many of the countries. So we wait to see what the final outcome will be for this discussion. So I think I'll leave it at that for now and hand it back to Hugh, and also looking forward to hear views from the other colleagues. Thank you.
Great, thanks so much for that, Ritah. And again, there was a lot in there that can be picked up on. I mean, one interesting thing there, which isn't so much for today's discussion, but I think should be talked about a bit more, is this point on sustainable development. I mean, one of the things that gets talked about a lot with Article 6 is the fact that there's a transfer of the carbon. So carbon goes from one entity to another, but all of the sustainable development benefits stay in the country. And so there is a kind of real value in credits under Article 6 and projects that have significant sustainable development benefits, because those get retained. Josh, we're going to come to you next to hear from the project developer's perspective, but in particular from TASC, how you're looking at this. So TASC is a developer who's been around in the market for a while, and it'd be great to hear a little bit more from you about how, as a project developer, you're viewing the introduction of Article 6. How do you see the option to generate credits and to run projects under Article 6? And what are you seeing in terms of interest from buyers, if anything, and how are buyers considering Article 6 from a pricing perspective, but just more generally, how are they looking at this?
Okay, yeah, thanks very much, Hugh and Gold Standard. I think this is the first time TASC's been on a call, so we're really pleased and particularly grateful to be alongside this esteemed company today. So TASC is a project developer. We're operating in South Africa, Uganda, Zambia, and Zimbabwe. We've distributed over 400,000 cook stoves in quite a short period of time. Cook stoves is our bread and butter, I guess. But we have also recently branched into water filters, and in South Africa, soil carbon sequestration through improved grasslands. I think in the future, we plan to do a bit more of everything, certainly a lot more cook stoves. So we're seeking, LOAs in every country where we operate or plan to operate, except for South Africa, because South Africa is a compliance market for us, and it seems very unlikely that, one, you'd want to export the credits out of South Africa, and two, that they'd give you an LOA anyway. So we're not doing it there, but everything I say on this call kind of speaks to the other countries we operate in and the region. The majority of our projects, like I said, involve distribution of household devices, and I think they're going to be less complicated than land-based projects to get corresponding adjustments. In our limited experience looking at new project opportunities, the land-based ones have been more complicated to even begin to negotiate an LOA, because you start interacting with land and asset rights, established laws or laws that are in the pipeline. And because of that, I speak personally saying that I'm much more confident about getting LOAs for household device projects than land-based at this point. We've been engaging with authorities since last year, and I think the name of the game so far has been patience. We understand that a lot of the officials are conferring with one another. They want to share their experiences, perceptions of Article 6. Some are taking time because they clearly want to create the right incentives for investors. I think others are trying to work out the level of fees that the market can bear, and I'm really interested to hear from my colleagues on the call or what they think about that. On the demand side, voluntary buyers are definitely interested in corresponding adjustments, because I think it means something to contribute to a global framework on climate change. And I think certain companies understand that it's a strong message to show that alignment. It means something to show that you understand climate change is a global issue. And I think some companies can get wrapped up in very single issue stuff, and it can work to their detriment. So this is a great opportunity. And it's also an opportunity to move away from carbon neutrality, maybe towards more statement offsetting part of your business, contribution claims. All of these things. It can mean more to try and contribute to the Paris Agreement and purchase credits from this nascent market than perhaps the established VCM. I think not all buyers are interested. It feels roughly half and half. And for those that aren't, I think they're either wrapped up in a kind of a particular pet project type, maybe a tech-based removal or something that they feel is very important to them, or they are generally skeptical of the UN, Paris Agreement, political process, and therefore less interested in CAs and really have little faith that they'll mean anything. Just to wrap up, I think we're going to talk about price. We've seen that those interested in corresponding adjustments are already willing to pay a premium for them. You said they don't exist in a registry, but you can talk to buyers about the potential sale of corresponding adjustments. You can talk about pending corresponding adjustments, and there's a willingness to pay a premium. Like, that is established for us. I think traders, the main traders, see an opportunity in accumulating credits with certain characteristics that mean they will remain fungible across voluntary and compliance applications. That's just good trading. That's just trying to assess the situation we're in. Other end buyers want corresponding adjustments, and they already, particularly if they've bought carbon credits for a few years and they've seen supply and demand of certain projects wax and wane, they understand that these new characteristics will make certain credits more constrained to the market that they've been operating in. So they recognise that it just has to be a premium. I hope that's a reasonable answer. I think that's kind of all from me for now.
Great, thank you very much, Josh. So, I mean, I'm going to turn to Russell in a second, but I think so far there may be things which I've missed here, but I've heard a few of the different reasons why I think you may see price differences in the future for adjusted units. So we've talked about the potential for levies, which is kind of one component of it, or some other form of benefit gaining or sharing, whatever you want to call it, from the side of the government. We talked about the potential for Article 6 activities to represent and come from, so credits to come from different types of activities which represent higher hanging fruit. So in harder to abate sectors where the actual cost of mitigation on the ground may be higher, so a higher price is needed for them. So that's kind of another component. And then Josh, to me, brought in a couple of other points there as well. One is simply the scarcity issue. So we may see more scarcity of adjusted units in the future, which kind of drives the price in a certain way. And then this point about use across different markets, which I think is important. So if in the future adjusted units are usable across different markets and for more applications, then that contributes to the price as well. So I'd be really interested in kind of gathering any other thoughts, any other drivers of price as we go forward. But those are some of the ones which we've had so far. And now turning to Russell, who knows a lot more about pricing and how the market prices things than I certainly do, and many of us do. So it'd be great to hear about this from the CBL perspective. So I mean, CBL kind of runs as an exchange, develop benchmark contracts that have helped the market to scale up and supported price discovery in a market that typically buyers have found it quite hard to understand the price that they should be paying for credits. So there's a lot of work which exchanges have helped with there. It'd be great to hear a little bit more about, from the CBL perspective, if you are thinking about this already, how you're thinking about the introduction of adjusted credits into the market, and what role, if any, you see for an exchange like CBL in supporting their trade.
I appreciate you having me on, and already really interesting dialogue so far. I'm jotting down notes of different things to think about as I hear the other panelists speak. So yeah, Expansive is as a spot exchange. We focus on environmental commodities. So we host renewable energy credits, Australian water, compliance carbon, digital fuels, which are more like sustainable commodities, kind of next generation commodities. And we are the single largest point of liquidity or market for voluntary offset credits. So we were about 40% of the market last year. And I should mention that, prior to Expansive, I was at CME Group for 10 years, also kind of launching contracts in environmental markets as well as traditional, like oil and refined products and NGLs and ethanol. So plenty of experience launching standardized contracts, but nothing is quite like voluntary carbon, where we're working with the top traders in the world and some of the best kind of policy experts. We're all trying to hit a moving target here, where the rules are changing and evolving, and I think everyone's excited, and we're happy where the market's come so far, but it is definitely a work in progress, especially around Article 6. But just in general, I mean, the reason why CBL started in 2009 was because, why do you need standardized contracts? They're for opaque markets where firms are looking for near long-term guidance on price, risk, and opportunity. So for sure, the subject of this panel and something that customers are starting to think about. And really, when we're designing any sort of commodity or standardized instrument, the debate and the trade-off is always going to be around liquidity versus how specific you want to get that price. So ideally, you have a very liquid market that's, for firms like, TASC and with Josh, that's very specific to their project, because you want to use that to help manage your long-term risks and project, what the prices can be when you're looking to finance additional projects. But you also, in addition to having something very tightly correlated to your specific need, you also want something with lots of liquidity. You want buyers and sellers and lots of different optionality and the ability to host things like electronic markets, which are open and transparent. So it's not going to, that's the case for every commodity market that I've dealt with. That will be the case for how we handle Article 6 and corresponding adjustments as well. And we have experience hosting kind of a variety of standardized contracts. And these are contracts when, instead of just buying and selling a specific project, you set a specification where, for our GEO contract, which follows the CORSIA framework, you have 35 million tons that deliver into it. And again, similar to Josh's point about some firms looking at to align with Article 6, some voluntary buyers to align with Article 6 and align with the UN. That's actually why we picked CORSIA and GEO as our first prototype for these standardized instruments. And we've seen firms, even set kind of internal mandates to buy credits off GEO for their own internal offsetting, because it follows CORSIA, because they can give that example that it's tied to the UN, that the airlines are going to use it. So certainty is a really important thing in this market, and any sort of structure or framework that is transparent and provides more certainty is going to be attractive to buyers, and we'll look to see how we can provide better pricing and products around that. Now, at the same point, we have big products like our NGO, our nature-based global emissions offset, and our CGO, which are tech-based credits. So while GEO has 35 million tons, our NGO contract has over 100 million tons. And NGO is an anchor in the market, and it's supposed to represent a wide array of nature-based credits, because again, that's more of a long-term hedging tool. So of course, there's plenty of activity in the spot market on our exchange, but in the associated CME futures market, you have firms that are putting out positions out to 2025. You have firms that are in the next month. CME is going to extend that out to 2027. So that benchmark, which actually we actually did adjust NGO to allow for corresponding adjustments, could be credits with corresponding adjustments could be delivered into it. It's a seller's option, so I assume most firms would not deliver a corresponding adjustment into it. But that benchmark is supposed to be a large pool of liquidity, and then from that, we imagine that a variety of different basis markets will occur. but we wouldn't change NGO because of that long-term open interest in the futures and the fact that it's kind of like an anchor in the market. So we'll have these large benchmark contracts that are important price signals, but may not like specifically request things like corresponding adjustments. In terms of what we need to start to get to how we show prices on our exchange and put out different indices and products, first is going to start, with like the gold standard and the registries. They need to start, and I know they're going through this process now, tagging projects with corresponding adjustments. And once we have that data, like we have, the registries are like a treasure trove of data. What we do as an exchange is we try to bring that data and information to the surface, and then we pair it with our transactions. So even though standardized products like NGO make up about 30% of our volume, 70% still is project specific, where firms are focused on, what's the vintage year, what's the country, what's the region, what's the project type, what are the co-benefits. All of these factors play a role in how we value offset credits today. And as we start to layer in the corresponding adjustment tags with all these other factors, we'll look to see, I think Mischa was saying that there would be some ways to standardize this market, just looking at the initial policy analysis. I'm really curious to hear more about that because it seems like it's fairly bifurcated and different countries are going to come on at different times. But as we get some like regional cooperation and we start to get some transactions through and these are tagged and we can track the data, then we can either feed them in through our partners like S&P Platts and they can start putting out indices. So just firms have like a basis to our benchmarks. Or once we get enough supply where we feel like we could support a contract with enough liquidity on our platform, then we could start issuing specific credits that would be tied to the corresponding a credit with a corresponding adjustment. But it's early stages and it remains to be seen. Again, will it just be nature-based projects with corresponding adjustments as a premium to NGO, for example? Will we pull out the corresponding adjustment and value that on its own? It's something we're still grappling with for things like co-benefits today. Like, SDGs aren't, it still remains to be seen what's a project with 3 or 4 or 5, like what's the differential there? It's going to be the same exercise with corresponding adjustments. It's the same thing we're grappling with on our digital fuel side. We're collecting a lot of data on how natural gas was produced in the United States. We'll look at the methane content. We're stripping out that as a methane performance certificate to try to discover what the willingness to pay is for low to zero methane production for natural gas. But is that going to be the right way going forward, or is it going to be just a sustainable MMBTU of natural gas? Like that's going to be the same conversation, the same thing we look at in this area. So there's a lot of moving parts, a lot to digest, for sure on this one.
Thanks. That was incredibly interesting. And I mean, I think things have moved on a bit from them, but if you go back to the task force on scaling the voluntary carbon market, so what's now become the Integrity Council, I think around this time last year, they came out with their final report, and in there they had core carbon principles and then 5 additional attributes, so kind of attributes that credits may have, including kind of whether they have adjustments or whether they're not adjusted, so adjusted under Article 6. And 5 kind of felt quite simple to me when you look at this, but then when you think about it in terms of what you were just saying there, Russell, there's quite a lot of different combinations of those 5 which could come together, and how you structure this to meet buyer demand is pretty challenging. So that was really interesting. Thank you very much for that.
Yeah. Just quick in that, I mean, the vintage years is going to be the big another, because there's like 10-year blocks that overlap in my understanding of from some of the policy experts we work with, and we have vintage debates all the time in the voluntary market today. So yeah, a lot of moving parts that'll be up for debate.
And I'm going to turn to Malwina in a second, but just one more little point on that. So Russell, you mentioned kind of this starting with the registries, and we've been working for a while on introducing the functionality in our registry and gold standard to show when credits are authorized under Article 6 and when they're adjusted. And that's something which will come on, we hope, within the next month, and we'll share more information about that from gold standard. We need the credits to come forward to show under that, but the functionality will exist for that to be done. And Malwina, we're going to come to you now from EY Law. So we've been working together between Gold Standard and EY Law over the past few months to look at the question of how the transition to a new context into the Paris Agreement affects or may affect legal rights related to carbon credits, which I think is really relevant for what we're talking about today on pricing. And it'd be great if you could share a little bit more about this topic, as well as some of the potential consequences we could see for value.
Sure, Hugh, thank you so much for the introduction, and happy to be here. It's also EY's first time at the Gold Standards webcast, so great to be among those distinguished panelists. I'm representing EY Center for Climate Policy. We basically combine the regulatory advisory and business consulting on international and local climate policies. And this includes carbon pricing mechanisms such as the EU ETS and carbon border adjustment mechanism. We also advise clients on the voluntary carbon market, and since not that long ago, also Article 6. And our clients are basically governments, corporate buyers, but also project developers. Recently, we were conducting a study for the Australian Climate Change Authority on the determination of quality of carbon credits, and we are also helping project developers on certification processes. With corporate buyers, we help them enter the voluntary carbon market and also review their carbon credits portfolio. And as Hugh just mentioned, over the course of summer, we've been preparing a report on how Article 6 will impact the rights to carbon credits, and why we think this is important from the perspective of valuation and pricing of carbon credits. Well, first of all, Article 6 will put certain limitations and obligations on project developers, and also, as Ritah mentioned, certain levies on project developers. So this, of course, will cause more additional administrative burdens to project developers, additional fees that they will need to pay, which will translate to a higher cost for them and a higher price effectively. Secondly, some of the impacts that Article 6 will bring may limit the ability to trade in carbon credits for the developers, but at the other hand, it will broaden the scope of demand significantly. And this too, in our view, will have an impact on credits pricing. Before we jump to the types of rights and what are the implications for project developers and carbon credits holders, I would like to make the comment that Article 6 and the obligations it is bringing to the market, it is not a novelty to the market, because we all think that voluntary carbon market is an unregulated market, that it functions like not in the regulatory scope, but this is simply not true, because from the beginning, this market was always in a context or in some regulatory frameworks, being the international frameworks or first Kyoto Protocol, now Article 6 and the Paris Agreement. And each project developer is working in a specific jurisdiction, and specific national regulations always apply to carbon credits and projects. So always the obligations, or rather the rights of project developers to carbon credits are affected by various laws, and Article 6 is just yet another angle to this whole framework. In the report, we distinguish three types of rights that will be impacted. So this is the right to generate carbon credits, a right to own carbon credits, and right to use those credits. And I will briefly speak about the right to generate and own, and we'll spend a little bit more time on the right to use. Through right to generate, we understand project developers' right to certify their projects and to have their carbon credits issued. And in our view, this right will be only to a limited extent impacted by Article 6. And this is because, of course, Article 6 will bring the obligation of project approvals and then authorization by host governments. Probably many governments will be building their own registries where project developers will need to register their projects. But it's definitely not a novelty to project developers, since they needed to do so under just different frameworks. So Article 6 will be just yet another framework that they will be using, but basically it will, in many cases, be similar to what project developers needed to do already. With the right to own, the case is even more simple, and here we don't think that Article 6 will even apply or had any larger effects on the right to own, because right to own carbon credits is always connected to the right to own the project itself. And by project itself, I mean the right to own the land where the project is based, the right to use natural resources that the project is using, and in some jurisdictions, those rights stay with the private entity, the project developer, but in other jurisdictions, those rights are always in the command of national government. And in this case, the right to own carbon credits will be limited by the rights of national government, but Article 6 rather won't have much effect on this right. The situation is much different with the right to use carbon credits, because we were all used to the situation where carbon project developers, but also the buyers and basically owners of carbon credits had a free will at how those credits will be used, where they will be sold and how they will be sold. The only limitation was, of course, the rule of double counting, or rather non-double counting. But apart from that, project developers were free to use their credits. With Article 6, the situation will be much different, because the scope of use purposes of ITMOs will be limited to only a couple of use purposes. So those ITMOs, those mitigation outcomes, can be used towards other countries' NDC. They can be used towards international mitigation purposes, such as CORSIA, and in some cases for other purposes. This will include the voluntary carbon market. But it won't be the project developer that will be deciding which of those options to use. It will be the national government, the host government, that will be deciding which of the use purposes will be available under this country jurisdiction. So this is, I would say, the greatest novelty for the market participants when it comes to how the credits will be traded and what kind of responsibilities and what kind of opportunities will come to project developers. Because currently it is up to project developer to make sure that the credits are sellable. While under Article 6, especially under Article 6.4.2, excuse me, it will be the responsibility of host government to sign bilateral agreements and to make sure that the credits are actually getting sold. This is also a large opportunity for project developers, because currently carbon credits are rather not available for use to use towards NDC, to use towards CORSIA, or maybe other compliance pricing schemes, while Article 6.6, both 6.2 and 6.4 will enable this new market demand to be available for project developers. And this, of course, will have implication on the value of credits and on pricing of credits. As the new demand will, as Mischa had said, it will change the market from buyer's market to the seller's market. Yeah, and maybe I will stop here and see how the discussion goes.
Great, thank you so much, Malwina. Thanks for that. Okay, we have about 10 minutes left, and we have some really, really good questions in the chat. So I'm just going to go straight into the questions I think that we've got. I'll try to ask the questions to one of you, but then others feel free to come in on the question, but also just to react to anything which you've heard from others as well. Where to start? I'd like to start, Mischa, I know that you've answered this in the chat, but with one of the questions which has come through, and Ritah, you may want to answer it as well, about capacity building I think the question was for the government itself. So capacity building for the government to ensure the government has the right understanding in order to be able to make the correct decisions about what to authorize. It'd be great to hear from you a little bit about this, both Mischa and Ritah, and then we can open up for anyone else to come in as well.
Yeah, that's probably among the most important things for seeing markets really emerge, capacity. And I think from what I experienced, we met a lot of really diligent and well-trained people in the partner countries, and my feeling is that capacity building much more is, I mean, the bottleneck is about the political work that needs to be done, the capacity of the governments to establish the ground rules for Article 6. And as I believe it was Russell said, I mean, as soon as the rules are clear, you also can do capacity building, because there is a rule out there, eligibility criteria, procedures, and everything. So, and I would bet the market would do its own thing to educate staff, project or potential project proponents, and also government, if needed, to find the opportunities for projects. And I think that's also the point where host country even should do a decent level of levying and like funding of their own infrastructure to really get things going. And as soon that works, I believe also capacity building will be done automatically, because it means business. But the ground rules must be set, requirements must be like decided, and this is not done in a webinar. This is done in a cabinet, and that's hard work.
Great, thank you. Ritah, anything to
Yeah,
add?
absolutely, and I fully agree with Mischa. I think one of the key things, of course, we saw now we do a lot of course learning a lot of lessons from the CDM. So before, like Mischa was saying, capacity building for the host government. So previously, a lot of this responsibility was falling on the ministries of environment or those that are dealing with climate change. But we see the Article 6 bringing a sort of twist now to even involve the ministries of finance in the very core decision. So in the institutional frameworks, in setting up this whole process from the bottom up. And I think this is some of the interests. I've been really enjoying the discussion already in the chat. And I think these are some of the key aspects that are being brought up in the chat in terms of purchase agreements. How are these actually going to be dealt with? So without that capacity that cuts across all these key institutions, it's still a bit difficult. But currently we see that most of the countries in the region are actually now very open to having this as a key aspect right now before even they get anything started. So that's capacity for corresponding adjustments. There's been already that discussion in the chat as well. Registries and the like. So having financial incentives in place and then getting it started. And of course, at this point, nobody wants to hear the word tax because that's really additional to the burden that's already ongoing, at least for most of the countries. So of course, the discussion is how to term it, how to incorporate it, what percentage is it. There's all these discussions going, and I think this will definitely affect a lot of the discussions with the MOPAs and with how the different institutions will be ready to include this within their strategies and plans moving forward. Yeah, thanks, and back to you.
Great, thanks, Ritah. We've had a couple of questions on RED plus credits, which Russell, I may come to you for something initial, and then others may want to come in as well. So one of these was from Robbie about plans by Gabon to issue 90 million non-adjusted credits in the near future and what that may do to the market. And then another one, which anyone's welcome to answer if they wish to, which is about negotiations which are carrying on Article 6 about whether RED plus credits will qualify under Article 6 or not. So there is still an open question, as I understand it, about maybe, I think there's mixed views on this, but maybe about whether avoidance-based credits, avoidance-based mitigation outcomes are eligible under Article 6 or not, and RED falls into that. So Russell, I don't know if you want to comment on the first one, Gabon, if there's anything which you're hearing on that, and then anyone else who wants to come in on these questions, please feel free to.
Is Gabon, are we talking about RED dot plus versus RED symbol plus?
I believe we are here, yes.
We actually do not provide RED dot plus credits through our platform. So we're fairly agnostic on credits. As long as there's a market, but I can't really comment on RED dot plus just because we don't facilitate those transactions through our platform today. you know, it depends on the standards. Avoidance versus removals in general, looking outside of just red dot plus. Again, it comes back to the fact that these are things that are just starting to be tagged by the registry, similar to CAs or things like blue carbon. It's the things that firms really want to see. How are they pricing, get transparency on? But without the supply, you know, we don't really have the data to support it. It would be interesting to this point, I don't mean to go off track, but to hear more about on the panel, if there's any consensus around what this high hanging fruit will be in terms of like, do the removals versus avoidance debate, does it play into that? Is it going to be different at a country by country or a regional level, and how, you know, how we see firms and what types of projects we'll see get delivered or defined as high hanging fruit from an exchange? That would be interesting for us to think about. I don't know if I could throw that question back out to the group.
Yeah, Josh, I see you've unmuted.
Yeah, I mean, I think it's actually a great little deviation, Russell. So thanks for taking us down that path. Look, I'm sure Ritah, maybe the others can talk more about, you know, the perspective in the government. Our view is that, and you know, to take this with a pinch of salt, is that once these markets become more formalized, the market will do its thing, and it's gonna go for the lowest hanging fruit first. Now, where that floor is, we don't know, but like as soon as you formalize this market and you get scale, which we all want, then the market's gonna, you know, it's gonna go towards the lower hanging stuff first. But where the floor is very much going to be determined by, we could call them quote unquote buyer countries, or Paris Agreement signatories, which legalize like a demand either through their own national purchasing program, through voluntary carbon regulations, basically telling companies what they can and can't use because they're tired of greenwashing and all sorts. Maybe they change their tax, or they institute a new tax, they institute a new trading scheme, and carbon credits have always been used for flexibility in the early years of these tax and trading schemes. So, I mean, our view is that like which fruit is picked is going to be what the lowest hanging possible will be picked first in this Article 6 world, because that always happens. Like, and you know, it will definitely happen. But also, like how low you can go will be determined by the buyer countries and the movements that they make, hopefully very soon. I mean, Mischa is pretty unique in his position. It would be nice to see more Mischas out there in more countries, including my own.
Great, thanks. Mischa, and then we're going to wrap up with one final question in the last 2 minutes we have. But Mischa, over to you.
Yeah, very briefly on the Gabon question, also linking to what Malwina said. I mean, the question is who is going to use it. I mean, and this is ultimately the question of the national framework. I know. I mean, just as an example, the KliK Foundation or also Switzerland, in that sense, excludes biologic sequestration from being eligible as a compliance instrument altogether. So these units are out, and also units that have been issued before. Also, I mean, the whole CDM transition discussion doesn't really affect us in a way, because national law provides that these units, the useful units, must be produced after 2021. So the whole discussion for us is a little bit futile, and also like the whole additionality case has to be proven. So I think that's the important question, and also the understanding that it was mentioned in the chat, the nationalization, it is a party game, and parties have the right and the power to overrule standards, and maybe they don't like the FNRB. They want to use different FNRBs because they're reporting under Article 13 also with their FNRB. So I think there will be changes, and also these changes will affect pricing quite dramatically.
Yeah, great.
Maybe, I'm not sure if I can make a comment to what Josh said. So very briefly, because I know that we are running out of time, but I definitely agree that the market will be going for the low-hanging fruit first, because this is what markets usually do. But I see a hope in harmonization of both Article 6 mitigation outcomes and the voluntary credits with non-financial reporting requirements and standards. So right now we can see that under TCFD or science-based targets or the EU taxonomy, there's no linking between those non-financial reporting standards and the voluntary market or Article 6. And companies will be seeing more and more obligations for non-financial reporting, where it will be said how they should decarbonize, how they should be limiting their emissions. And if credits and offsetting is not there, their incentive to use offsetting as one of the decarbonization tools will be much lower. So definitely harmonizing Article 6 mitigation outcomes and also voluntary credits with non-financial reporting standards could both help the market to gain new buyers, but also could help to raise the bar for the quality of credits that are being bought, because in those non-financial reporting standards, countries could like put the obligations for that companies could only realize those non-financial reporting obligations with certain types of credits. So I see it as a chance which is still unused by the market and by the international community.
Great, thank you. This is an event I wish was in person, because I think we've just got started on the conversation. So it'd be quite nice if we were to be able to wrap up now and to go to a pub and to carry it on afterwards, because there's so many different threads that we've talked about here that have come up in the chat that we haven't been able to answer. So I mean, what I'm thinking is this is a series which will carry on, and I'd love to come back and to look again at some of these topics later on. Nationalization, we didn't really get to talk about, but it is a big thing on people's minds. There's a lot of stuff which has come up in the chat, which we could spend lots longer on. We are going to close now. Thank you very much to everyone who's listened. Thanks so much to the panel, so to Ritah, Malwina, Russell, Josh, and Mischa for some really interesting contributions. Please do feel free to reach out to us, to add anyone on LinkedIn so you can follow up afterwards. And as was shared earlier, we will be sharing the recording from this, so you'll be able to see it, to share it with others, and to watch it back. But thanks very much, and we hope to see many of you on some of the other webinars in the future. Thanks.